Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an update on the Haldwani evictions. A bench comprising Justices Surya Kant, Dipankar Datta and Ujjwal Bhuyan today heard an application filed by the Union of India Railways seeking modification of the order which stayed the eviction of nearly 50,000 people who have allegedly encroached upon the railway properties in Haldwani. The railways stated that a retaining wall protecting the railway tracks was demolished by the violent flow of the Guhala River during the last year's monsoon and urged that a strip of land be made available urgently to facilitate the railway operations. The evictions from the railway lands were ordered by the Uttarakhand High Court in December 2022 in a public interest litigation. In January 2023, the Supreme Court stayed the High Court's direction and the interim order was extended from time to time. The bench today questioned the railways if they had done anything against the alleged encroachers who have been in settled possession of the land for several decades now. Justice Bhuyan said that instead of initiating statutory proceedings against them, the railway chose to ride on the back of a public interest litigation filed by a private individual. Justice Surya Kant pointed out that since many residents were claiming title based on documents, a PIL was not an effective remedy to address the disputed questions of fact. Additional Solicitor General Aishwarya Bhati requested the bench to lift the stay incrementally, citing that railway expansion plans have been hindered due to unavailable land. She stressed that Haldwani, the last station before the Kumaon region, is crucial as the gateway to the hills. The court acknowledged the need of the railways but stressed the need for humane treatment and rehabilitation of those affected. Therefore, it has asked the Union of India and the state of Uttarakhand to identify the essential strip of land needed urgently for shifting railway lines or constructing necessary infrastructure, determine the families likely to be affected by vacating this strip, and propose a site for their rehabilitation. The matter will be heard next on September 11th. Stay tuned. The Supreme Court has overturned a decision of the Guwahati High Court to reinstate a CRPF constable who was terminated for withholding important information. The court emphasized that the standards for hiring in law enforcement should be more rigorous than for regular jobs. The case here involved application for the CRPF constable position. The verification form required applicants to clearly state if they had ever been arrested, prosecuted, or had any pending cases, with a warning that false information would result in termination. The constable here answered no to these questions. Later, a private party submitted a written complaint stating that the constable had intentionally withheld crucial information, revealing 2 criminal cases against him. Consequently, he was issued a show cause notice detailing these charges, which he denied. Disciplinary proceedings followed, concluding that he had indeed concealed the 2 cases. As a result, an order was issued for his immediate removal from service. When the same was challenged before the High Court, it reinstated him and observed that there were no pending criminal cases against him when he filled the form. It was also noted that he was quite young at the time and might have made a mistake in providing incorrect information. The division bench also upheld this order. Hence, an appeal was filed before the Supreme Court. The bench of Justices Hima Kohli and Ehsanuddin Amanullah have observed that the constable was arraigned as a co-accused in the criminal case. He was taken into judicial custody and was granted bail by the trial court. That all this had transpired much before he was called upon to fill up the verification role. In view of this, the court refused to accept his plea that he had no knowledge of his implication in the criminal cases. The court also noted that the constable's case was not a clean acquittal because the prosecution had failed to prove its case beyond a reasonable doubt. The top court opined that the High Court erred in its findings and the constable did not deserve any latitude. Thus, the court restored the order of the disciplinary authority. The Supreme Court today heard a petition filed by the state of Haryana against an order passed by the Punjab and Haryana High Court directing it to unblock the Shambhu border, which was closed in February this year to prevent the movement of protesting farmers from Punjab to Haryana. The farmers, as you must be aware, have been protesting there, raising demands such as a statutory guarantee for the minimum support price for crops. Solicitor General Tushar Mehta, appearing for the state of Haryana, today submitted that over 500 to 600 tanks, which had been modified as armoured tanks, were stationed at the site, and if they were allowed to travel to Delhi, law and order situation could arise. While saying that the state need not allow the use of tractors, trolleys or JCBs, Justice Suryakant said that there appeared to be a trust deficit between the government and the protesting farmers. Advocate General of Punjab Gurminder Singh submitted that the blocking of the national highway was affecting the economic health of the state of Punjab as well. The court expressed its intention to form a committee of independent persons who could negotiate with the farmers protesting at the Punjab-Haryana border and the governments to find a resolution to the issues. It has asked the states of Punjab and Haryana to suggest the names of suitable individuals who can be included in the committee. Till next week, the court has directed that status quo be maintained by both the states at the protest site. The court has also asked the states of Punjab and Haryana to suggest a proposal to remove the barricades at the Shambhu border to prevent inconvenience to the general public. A bench led by Justice B.R. Gawai of the Supreme Court has today halted the contempt proceedings initiated by it against the Delhi Development Authority Vice Chairman over illegal tree felling, after noting that another bench led by Justice A.S. Oak took up the same contempt case later. Justice Gawai pointed out that it was his bench which had initiated the contempt proceedings against the DDA first on 24th April. Therefore, he added that Justice Oak-led bench ought to have sought clarifications from the Chief Justice of India before initiating contempt proceedings against the DDA on the same cause of action later on 14th May. Let me tell you, Justice Gawai's bench is dealing with the T.N. Godavarman case, in which the Supreme Court has been issuing various directions in relation to forests across the country since 1995. And the bench led by Justice Oak is dealing with the MC Mehta case, which specifically relates to the environmental issues relating to the Delhi NCR. Justice Gawai's bench today passed an order pausing the proceedings in the contempt matter initiated by it on 24th April. It referred the matter to the Chief Justice of India, D.Y. Chandrachud, for clarification. In another important update, let me tell you that the Apex Court is set to examine whether the right to be forgotten can be enforced against the judgments by courts which reveal the identity of the acquitted person. The bench of CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra was hearing a challenge by a legal database website named Indian Kanoon against the Madras High Court's order of 3rd March. The High Court had directed the portal to take down copy of a judgment which revealed identity of a person who was acquitted in a sexual assault case. The impugned order observed that though the courts were expected to preserve data as a court of record, it was also required to strike a balance between the collection of such data and the protection of a person's personal data. The counsel appearing for the respondent, who was the original petitioner before the High Court, informed the bench that he had sought for removal of their identities from the judgment available on the High Court website as well as from Indian Kanoon. He further stated that due to the revelation of his name in the judgment of acquittal, he was denied Australian citizenship. The counsel for Indian Kanoon stated that the website takes its responsibility of masking domestic or sensitive cases seriously, even in the absence of any express legal obligation to do so. However, the present case, he said, did not fall in the category of cases where masking of identities was justified. He further said that the decisions of the High Court on the issue of the right to be forgotten were at loggerheads. While the Kerala and Gujarat High Courts hold that there is no right to be forgotten, the impugned order of the Madras High Court says to the contrary. He stressed that there was a genuine question of law emerging from contradictory judgments from different high courts. During the hearing, the CJI raised concerns about the High Court's directive questioning how a publicly available judgment could be ordered to be taken down. He emphasized that once a judgment is delivered, it becomes part of the public record. That while the court might sometimes request masking of names in sensitive cases, ordering the removal of an entire judgment was far-fetched. The CJI stressed that such a precedent could lead to requests for removing judgments in other types of cases also. Thus, the court, while issuing notice in the petition, has stayed the Madras High Court order. And now an update on the defamation case against The Wire. Ex-JNU Professor Amrita Singh has filed a criminal defamation case over a report published in The Wire. The complaint was filed in 2016, wherein she has referred to an article written by The Wire's deputy editor in April 2016 titled "Dossier Called JNU Den of Organized Sex Racket, Students Professors Allege Hate Campaign." Singh had claimed that the publication imputed that she prepared a dossier allegedly depicting JNU as a den of organized sex racket. The complaint alleged that the editor did not verify the authenticity of the dossier and used it for monetary benefits of its magazine, defaming Singh's reputation. The summoning order was passed against The Wire's editor and deputy editor by a Delhi Metropolitan Court in 2017. In March last year, the Delhi High Court had quashed the summons issued in this case. Challenging the High Court's order, Singh approached the Supreme Court. Last year, the top court had also asked the Jawaharlal Nehru University to inform if any such dossier was prepared. In response, the JNU told the court that it had not received any dossier which was allegedly prepared by Professor Singh, describing the university as a den of organized sex racket. Today, the bench of Justices M.M. Sundaresh and Arvind Kumar has set aside the Delhi High Court order quashing the summons. It observed that the High Court, in the impugned judgment, while finding fault with the reasoning adopted in issuing the summons, went ahead and decided the matter on merits, holding that no case of defamation is made out, thus exceeding its jurisdiction. In view of this, the court, without expressing any opinion on the merits, has set aside the impugned judgment and remitted the issue of issuance of summons to the magistrate. Today, the Supreme Court in Senthil Balaji's bail plea asked the Directorate of Enforcement to show that the pen drive recovered from Balaji's residence contains a file which allegedly has evidence of proceeds of crime worth 67 crores. MLA and former Tamil Nadu Minister Balaji has been accused in a money laundering case linked to the cash for jobs allegations. He was arrested by the ED in June last year and has challenged a Madras High Court order that denied him bail. In its prosecution complaint, ED had relied on a file which allegedly contains evidence of Balaji receiving 67 crores as proceeds of crime from the alleged scam. Earlier this week, senior advocate Mukul Rohtagi for Balaji had contended that the file was not part of the pen drive recovered from Balaji's residence. A bench of Justice Abhay S. Oak and Justice Augustine George Massey today heard Solicitor General Tushar Mehta and advocate Zohaib Hussain representing the ED. Hussain said that the file was part of the materials seized by the Tamil Nadu police in the predicate offence and that the ED obtained the material from the PMLA court. He said that the device was a pen drive found in Balaji's residence. It was an HP pen drive marked as item number 5 in the Panchnama. Justice Oak then said that the ED must show that the pen drive marked as item number 5 was indeed sent to FSL and that the file was found in it. In another update, a Delhi court has issued summons to YouTuber Dhruv Rathee in a defamation suit filed by BJP MP spokesperson Suresh K. Nakhwa. Nakhwa has alleged that Rathee referred to him as a part of violent and abusive trolls in his YouTube video titled "My Reply to Godi YouTubers Elvish Yadav." He alleges that in the video, Rathee has claimed that Prime Minister Narendra Modi had hosted violent and abusive trolls like Ankit Jain, Suresh Nakhwa and Tajinder Bagga at his official residence. The suit adds that the video has received over 24 million views and more than 2.3 million likes. It adds that as a result of Rathee's allegedly defamatory statements in the video, Nakhwa's reputation has been severely damaged. The false accusations made by Rathee have led to his widespread condemnation and ridicule, causing irreparable harm to his personal and professional life. He has thus sought 20 lakhs damages from Rathee for defamation caused to him on cyberspace. District Judge Gunjan Gupta of Saket Courts issued summons in the defamation suit filed against Rathee as well as Google LLC and X Corp. A PIL plea has been moved before the Allahabad High Court challenging the directive of the Varanasi Municipal Corporation to close down all meat and poultry shops along the Kavan Yatra route for the entire month of Sawan. The National Loktantrik Party, through its national president Mohammad Suhail, has moved the PIL plea to quash the impugned directive and declare it unconstitutional and invalid. The PIL contends that the directive not only violates the fundamental freedom to carry on any occupation, trade or business, but also breaches the fundamental right to life with dignity and personal liberty. The PIL plea further states that the practice of Kavan Yatra in Sawan is an age-old practice and the meat shops have also existed since then. Therefore, passing such directives by the present authorities is trying to create an exclusion by identity. The PIL further contends that the directive will directly impact the livelihood of the shopkeepers, as the earnings from such shops are the means of livelihood for the shop owners, and closing a business on the grounds of selling non-vegetarian items is unreasonable. For those of you who do not know, the Kavan Yatra is an annual pilgrimage undertaken by Shiva devotees. During it, they travel to key Hindu pilgrimage sites such as Haridwar to fetch holy water from the Ganga river. Justice PM Manoj of the Kerala High Court has passed an interim order of stay for 1 week on an order of the State Information Commissioner directing to make the Justice Hema Commission report public. Tomorrow was the last date given by the Commission to publish the report. The Commission had said that it was in the larger public interest that the report be made public. The Justice K. Hema Committee was established in 2017 and was tasked with studying and suggesting solutions for issues faced by women in the film industry. A plea was moved by movie producer Sajiman Parayil. He challenged the order of the State Information Commissioner to disclose the Hema Commission report after editing portions which affected the privacy of persons who gave testimonies to the Commission and other connected persons. The petitioner argued that making the report public would affect the privacy of the person who gave testimonies to the Commission. The petitioner said that the testimony was given under the promise of confidentiality. Even if some portions were edited, the film industry is so interconnected that even innocuous details could lead to identification of the person, which could lead to further harassment. The petitioner argued that the report includes testimonies of sexual harassment, but the alleged offenders were not given a chance to present their side, potentially harming their reputation and livelihood. The matter is next posted on 1st August now. Stay tuned. And lastly, the Delhi High Court today issued notice on the bail plea filed by Umar Khalid in connection with the Delhi riots larger conspiracy case registered under the UAPA. A division bench comprising Justice Suresh Kumar Kaith and Justice Girish Katpalia has sought response of the Delhi police and has listed the matter for hearing on 29th August. The court also listed bail pleas filed by co-accused persons on the said date for hearing. Khalid has been behind bars since September 2020, awaiting his trial under the UAPA for his alleged involvement in the larger conspiracy surrounding the communal violence that broke out in February 2020 in the national capital. His second bail plea was denied by the trial court in May. He has challenged the said order in an appeal before the High Court. The fresh bail plea was moved by Khalid after he withdrew his plea seeking relief from the Supreme Court, where he had challenged the decision of the Delhi High Court denying him bail. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.